100 plus years campaign, because we need to celebrate this occasion. And so this particular seminar is part of UWC's celebration. And there are other events, some have taken place already. So let us then introduce let me introduce our guest to you, who is still a firm friend of the faculty. And so Seehaam Semaai is a feminist lawyer and activist, and has been practicing as an attorney since 2001. Wow. She holds a BProc and an LLM from UWC, and she's currently the director of the Women's Legal Center. Just a couple of highlights from Seehaam's career. She was the director of legal administration in the Western Cape Regional Office of the Department of Justice and Constitutional Development. She was of course, the lecturer at UWC, as well as the director of the UWC Law Clinic. She's a chairperson of the Lawyers for Human Rights. She is the chairperson of the Western Cape branch of NADAL, and she was nominated in 2018 as the National Gender Convener, and she also serves as an executive member of the South African Women's Lawyers Association within the Western Cape. So quite a full career. And I just wanted to highlight something about her current position, or the place where she's currently situated, the Women's Legal Center, which is an African feminist legal center that advances women's rights and equality through strategic litigation, advocacy, education, advice, and training. The center has a vision of women in South Africa so that they can enjoy equal and substantive access to rights, with the objective to drive a feminist agenda and to develop feminist jurisprudence based on, importantly, intersectional approach and with substantive equality as a foundation. So with all that said and done, I would like to then hand over to Seehaam Semaai. Thank you so much. And you have been made a host, I think it is, so you can go ahead and share.
Yeah, thank you. I'm a bit technologically challenged, but let me see. Let me do this. Okay.
I'll let you know. And you are a co-host, so it should be coming through soon. It's coming through.
Is it?
There it is. Perhaps you want to put it into the presentation mode.
Presentation mode. Yeah.
There we go.
Okay. Thank you. Yeah. So thank you. I mean, I'm not going to go again through the work that we do, but I mean, one of the purposes is also to develop feminist jurisprudence that advances women's rights. So it's very important in terms of our cases and to be able to ensure that the courts have the language or at least the language is that advances feminist jurisprudence. So I know that it's only an hour. I only have about 20 minutes most, but I think I'll just go through some of the slides, but because I'd like this to be a conversation. So we all know, I mean, I think it's important. I mean, even though I may be speaking to the converted, we need to be able to understand violence also within within apartheid and within colonialism. So it had a significant impact on violence against women in South Africa, which continued to be felt today. You will have noted that we work in an intersectional manner. So these particular systems of oppression were characterized by the systemic and institutionalized discrimination. So during apartheid, Black women in particularly were subjected to multiple forms of violence, which included forced removals from home, communities, sexual violence by security forces and white South Africans, and forced labor in the agricultural and domestic sectors. So similarly, colonialism in South Africa was marked by forced removal of communities. Black women in particularly were subjected to forced labor, again, sexual violence by colonial authorities. And we need to be able to contextualize this because these experiences of violence and oppression have had long-lasting impacts on women's physical and mental health, social and economic status, and access to justice. So the legacy of apartheid and colonialism continues to contribute to the perpetuation of violence against women. And so for us to effectively address violence against women in South Africa, it's important to acknowledge and address the historical and systemic factors that contribute to it. So this includes addressing the ongoing impacts of apartheid and colonialism, as well as working to change social norms and attitudes towards women and promoting gender equality. Sorry, let me just go. So I think also, I mean, we are in particularly using the definition as vow and also not GBV. I think it's important to note that the Women's Legal Center also uses the concept of vow and not GBV. But vow is a form of violence that specifically targets women because of their gender. And I think it's important to be able to understand possibly the differences and the nuances, because sometimes it's also used intersectionally, and we need to be able to see that while some overlap between vow and GBV, the distinction between the two is important because it acknowledges the different forms of violence that different individuals may face based on their gender or gender identity. So it also highlights the need for a comprehensive and intersectional approach in addressing all forms of GBV, which includes violence against women. And so the examples of vow is domestic violence, sexual assault, sexual harassment, female genital mutilation, and forced marriage, which disproportionately impacts on women, but in particularly Black women. So just going back into the framework to address violence against women, in South Africa, the legal framework for addressing violence against women includes different pieces of legislation. I've just noted a few, which I will go into, but it's only about 3 that I mentioned. But we have the Domestic Violence Act, we have the Sexual Offences, which is actually the Criminal Law Amendment Act. We've got the Trafficking in Persons Act, but also we have the Older Persons Act. We've got the Protection of Harassment Act, etc., etc. These were all pieces of legislation that came in post-1994 to be able to address the challenges of violence against women. So we will be, okay, so I will be looking more closely, but I'll just run through it. I think it's very important to look at the constitutional provisions. So all of these pieces of legislation is situated within the provisions of equality, dignity, and freedom and security of a person, which all are all critical in the protection of women from violence. So the Constitution is one of the most progressive constitutions in the world when it comes to protecting women's rights, including the right to be free from violence. So the Constitution is there for a very, very strong foundation for the legal framework and in the country, and also it is the basis of the various pieces of legislation. So firstly, I mean, I will just briefly look at the Domestic Violence Act. So the purpose of the Act is to provide for protection of victims of violence and to provide for matters incidental to it, whether or not you're married or unmarried. But in summary, the Act is important because it provides a piece of legislation for protecting victims of domestic violence and holding perpetrators accountable. So one of the key features of this Act is to be able to obtain a protection order. You can prohibit also your abuser from entering your home. It can also be used to be able to stop economic abuse. You can stop the perpetrator from coming to your home, your workplace, and also it prohibits the abuser from contacting and harassing the victim. So it's a very, very important piece of legislation. Then we have the criminal law, which is the Sexual Offences Act. This is this Act is very comprehensive. The Act is to provide for the protection of sexual integrity of people in South Africa and to provide for matters incidental to the Act. And also the Act includes a range of definitions of sexual offences, including statutory rape, which occurs when someone has sexual intercourse with a minor. The Act also recognizes offences of rape in marriage, very important, which is a crime that was not previously recognized in South Africa. The Act also sets out procedures for reporting, investigating. This includes providing victims with access to medical treatment, counseling, and the Act also provides for penalties. This Act also has brought in the National Register of Sexual Offences, and it provides various pieces of legislation that specifically deals with minimum sentencing and perpetrators, and it also the imprisonment and the time periods, etc., etc. So the sexual offences with another pieces of legislation, which is the minimum sentencing, is very, very important post 1994 to be able to deal with perpetrators of violence, sexual offences. Then we have the Trafficking Act. I'm just going to run through. I know I don't have a lot of time, but this particular act deals with trafficking in persons, and it covers a range of trafficking related matters, which is exploitation, forced labor, forced marriage, and the legal framework. It provides for penalties for perpetrators of trafficking, which includes fines, etc., etc. But with all of these acts, I wanted to show you some of the statistics from 2013 up to 2021, where you will see the number of sexual offences reported, sexual offences verdicts, and sexual offences convictions. And you will note that the attrition rate for reporting of convictions, because the challenge that you are sitting with is that even though the state is saying that there is a high number of conviction, but if you base it on the attrition as well as what has actually gone through the court, the number of withdrawals, etc., then the percentage of convictions is actually very low. Here it's a sexual offences verdicts and convictions, as you can see. Sexual offences verdicts, obviously, but then the convictions is much lower. And these are also conviction rates. And so you can see there that the NPA's conviction rates is fairly high, but our reality is actually the orange, because this is based on the amount of actual convictions and not just on the number of reported matters. So there are many challenges with the pieces of legislation. And what I'm going to do now is just to be able to look at the court and the constitutional jurisprudence. Many of you might have, dealt with these particular cases, but the court has been significant in developing the jurisprudence on violence against women. So I have the Carmichael case versus Minister of Safety and Security in 2001 that said sexual violence and the threat of sexual violence is the greatest threat of self-determination of South African women, and it goes to the very core of the subordination of women in society. It's very important language and also recognition of the challenge of sexual violence. The Masih case, which also dealt with sexual violence and rape, and it reflects the unequal power relations between men and women. And in F versus Minister, also entrenches patriarchy as it impels the freedom and self-determination of women. And then we're at Levenstein, which is also one of the Women's Legal Center cases, which contends that there is no factual basis or policy reasons to endorse the view that penetrative sexual offenses are more traumatic than non-penetrative sexual offenses. And the assumption that certain sexual offenses are morally offensive, or are more morally offensive than others. Patriarchal ideas about moral gravity and harmlessness of different sexual offenses. We intervened also in this particular matter, which dealt with the rape, not rape, sexual offenses within and whether or not it can prescribe. And all of those matters is now in the new legislation. And then we also have the Shabalala case. I mean, we can go through it much more in depth, where the court also pronounced that rape is a scourge that affects women. And we know that in South Africa, rape has a pernicious effect on Black women specifically. So this intersectional erasure is a rhetorical gesture, not only negates the lived experiences of women at these intersections of oppressed identities, but also means that our response to the crisis will be deficient and under-inclusive. So it's very important here to be able to look at that intersectional forms of oppression when we speak about violence against women. And the court obviously has recognized this. The court also acknowledged that there's a duty to develop and implement sound and robust legal principles which advances the fight of gender-based violence. So the constitutional framework, in the context, the challenge now that we have is that we have the pieces of legislation, we have the constitutional framework, we have the courts, developing that constitutional framework. But in the context where Parliament has failed to exercise parliamentary oversight and an executive that has largely become unaccountable, courts remain the most convincing approach to holding the state accountable for the failure to act with due diligence. So this is, you could see in relation to all of these cases. So the right to be free from violence, whether or not emanating from private or public sources, has received inadequate judicial attention. Its development implementation also remains incomplete. It's ongoing. So the initial constitutional cases, which I just mentioned, Carmichael, Van Eerden, Kay, the cases made a decisive link between violence against women and discrimination. And the extent of the legal development has been on the failure to act with due diligence and to prevent violations where the state failed in its duty to care. So I think many of you have possibly read the Carmichael case, but I will send you these slides also if people want to go through it. But what did the Constitutional Court decide? That there was a positive obligation on the police. The police had to reasonably protect women from sexual violence. There was a duty under international law, and that the police are one of the primary agents of the state responsible for the protection of the public. So the decision set an important precedent within its recognition that sexual violence is not a private matter and that public officials have a duty to protect women. So the decision of the Constitutional Court, also in Kay versus Minister of Security, represents the first steps towards the journey of modernizing the law of state delictual liability to remedy the violation of fundamental rights occasioned by the acts and by omissions of police. And the court also reformulated the test for determining vicarious liability for wrongful, negligent, or intentional wrongs committed by the public officials, which included police officers, so as to bring the concept of the policy within the framework of the spirit of the Bill of Rights. So the Supreme Court of Appeal and the High Court also developed the common law in line with Section 39(2). So there was various obligations that have been set out, are obliged to combat and investigate crime. And then also these obligations are there in relation to dignity and the freedom of security. And then there is also the NK case. I think maybe some of you have possibly read it. And then I've also set out in the NK case, what the court has set out and what they have found, that the common law test for vicarious liability in cases where employees deviated from the authorized functions required further development in the light of the spirit and purport and objectives of the Constitution. And so in answering the question whether even though an employee's act were committed solely for his or own purpose, there was sufficient close link between the employee's act and the purposes of the employer. So the court must give effect to the spirit and objectives of the Bill of Rights, and the minister was held vicariously liable. And then also we had the Van Eeden case. So just in conclusion, in relation to this broad legislative framework, the utility of allowing public authorities the freedom to conduct their affairs without threat or actions, for negligence in the interest of enhancing effective government ought not to be overlooked. It must also be kept in mind that in the constitutional dispensation, the state acting through its appointed officials are not always free to remain passive. Something needs to be done. The state is obliged to protect and promote and fulfill these rights. And so just briefly, with enforcement of this legal framework, there's law enforcement agencies. However, there remains challenges faced in implementing and enforcing the legal framework. Despite the existence of all of this, the implementation remains a problem. These challenges include limited resources, capacity challenges within agencies, inadequate training, lack of awareness among public, about rights, etc., high prevalence of underreporting, and then also, despite the challenges, there has been, as I've just indicated, there's legislation, etc., to improve responsiveness. But there still remain challenges. Civil society organizations have also played a significant role in awareness about this legal framework, and also address some of the challenges faced in implementing and enforcing it. But a lot of work still needs to be done, because our current reality is with implementation. And we could see this during 2018. Just quickly, I know my 30 minutes is up, but I just wanted to just also contextualize this within a broader movement, because the focus is that even though all of this legislation, the high rate of violence against women in this country was completely disproportionate. And in 2018, with the uprising of the total shutdown, etc., there was a refocusing of, women saying no and taking the state on, and to be able to say something needs to be done. But just quickly, before, there was a broad women's movement, obviously pre-1994, moving into a democracy, which was the Women's National Coalition. And the coalition was a political formation. It's old, but I think it's very important to be able to see this within the broader context of women advocating for rights and the advancement of rights. It's 100 years of women being in law. We all know of the March of 1956. And then also now we have this Women's National Coalition. So women have always been very active in addressing some of these challenges. And then post-1994, we've got a lot of national gender machinery, which includes, for example, the Gender Commission, the Parliamentary Joint Monitoring Committee, the Office of the Status of Women, etc. Sorry for that. Is my presentation still on? Hello?
Seehaam, something happened from your side.
My presentation, eh?
Yeah.
But anyway, I just wanted to speak to the movement, because a lot of work has been done to be able to see that we have all of these pieces of legislation, and to be able to, there's a lot of amendments currently that have come through in terms of the Domestic Violence Act, the Sexual Offences Act, they called it the 3 GBV bills, 3 GBV acts, to be able to strengthen the processes so that women can access the courts, for example. And the total shutdown, 2018, there was 24 demands. With those demands was taken to a national conference. And then with there was a national strategic plan that was developed with a council of government and civil society driving the drafting of this particular national plan. Last year, we had our second national summit to be able to look at what was the gains from the first summit, which was in 2018. There is obviously, I don't know, there's a lot of movement, a lot of civil society organizations obviously engaging with government on various levels to ensure that these proper policies, legislation, etc., to advance the rights of women. So, yeah, Karin, I'm going to leave it there. I know I've gone over my time by almost 5 minutes, but I don't know if you can have people have questions. Yeah, thank you.
Thank you so much, Seehaam, for showing us that broader context, the historical, but then also looking at the key legislation and the key cases that we have that have driven forward our way to try and find various things to deal with violence against women. But I'm going to open up to the floor now. And so if you can just raise your hand if you would like to ask a question, or if you can just type it into the chats and I will get around to it. But what I would like to possibly use my position as chair right now is just to ask a couple of questions of you. And first it's got to do with the center, and just to ask, just in a very practical way, how do you at the center use feminism or feminist theory and incorporate it into your litigation strategy and your advocacy strategy? So just that's the first thing that I find fascinating, because it is an alternative to traditional strategy and to the way you go about doing these particular things. And I see lots of chats are coming in, so I think you can also see it, but I'll read it out to you. But if you can first just address that one.
Yeah,
my question.
Well, in terms of our cases, I mean, what we develop, obviously, we do have a theory in relation to that particular, every particular program. Let me first say that the Women's Legal Center has 5 different programs, which all intersect with each other, which is the Violence Against Women program. We've got sexual health and reproductive rights. We have equality in relationships, we have access to land and housing, and then broadly women in work with a focus on vulnerable workers. So you can see that violence also intersects with all the different programs. So how do we, for example, develop our feminist theory, feminist jurisprudence, is that we look at, for example, how does the law, how does the neutrality of the law impact on women, and in what form? And what we do is that we highlight how the gender neutrality actually impacts on women in an intersectional manner. And so because like we said, that we develop intersectional jurisprudence, intersectional feminist jurisprudence. And so we highlight through our cases the lived realities of women, and to be able to understand the different level of oppression and how the law intersects with that, and what is the outcome for that particular person. We also use the law to be able to look at very particular principles that we wish to develop. So we will come in cases as amicus, etc., to be able to set the international or the regional standard, and to be able to ask the court to be able to look at the development of our legislation, or even that particular matter in line with international law. So we also look at the development of jurisprudence, but very importantly for us, we also use the law. We know that the law can't be used firstly completely for social change, but we try to use the law for some form for social change through ensuring that the client in itself, when they move through the justice system, that they are empowered and to be able to deal with their own realities. And that is also because you are developing the system to be able to ensure that there isn't secondary victimization, and that women will be able to access courts which is efficient and victim-centered and takes into account the realities of women and children on the ground. I hope there's a lot there in terms of theory. And I will be able to go on forever, but I see that there is a few questions. Let me just see. I don't know if it's coming to questions.
I think there are questions.
The one, vulnerable criteria created on sexual offences, specifically relating to
the group created for female students in tertiary institutions under 25. This creates a lot of concern since there's no clarity on what the term female refers to. Also, in the preamble, the Act informs women as a whole are deemed vulnerable and not just a specific group of women. So what is your take on this, since a lot will follow from this new vulnerable group created? Special protection now afforded under Section 170A of the CPA, intermediary services. I mean, a person can clearly perceive the hazards considering the provisions. I just scroll down. The provisions of the Constitution on part of the accused and victims, and how practical the section is.
Okay.
There's a lot in there.
It's a lot in there, yes. I mean, for us, I mean, female, I mean, when we at the Women's Legal Center, also in terms of our own interpretation and the narrative that we would like the court to possibly adopt, is that women for us, as all women in their diversity, so it's for us women with an X. So when we speak about violence against women, we talk about all women in terms of sexual orientation, transgender women, etc., etc. But those, I hope I'm answering you, but that is my take. That is the women's legal centers. And when we speak about interpretation, that is the perspective that we would go from. When we talk about the intersectional approach, we would look at it obviously through that lens of sexual orientation, sexual identity, etc., etc. So it's women in all its diversity.
A further question that maybe I'm picking up from that is whether it is, aside from looking at women and those who identify as women or male, the question is then, are women as a block or regarded as just a vulnerable group, or are there differentiations within the group called women, where we look at the most vulnerable, particularly due to intersectionality?
Yes, if you look at it through an intersectional lens, female, what you will see will be different.
Yeah,
because you will take into account the intersections, and you will be able to see how that oppression impacts on that particular woman.
I think
whether
that
not
the
it's
new
transgender women, whether or not, yeah.
I think that the amendments, the new amendments, will see the interpretation of that playing out later on as we have more case law around this matter.
Yes.
But I do think it's extremely interesting, and the question that is asked is quite interesting. I see yet another. Althea asks, could you please say more about the summit of the summit and the shutdown of 2018?
Okay.
Just a little bit of a history
around the rights of sex workers. Yes.
That's first Althea's, and then there's the issue of
yeah, I'll speak about Dikram.
The sex workers.
Yeah. What I'll do is that, let me just see if let me just get the lot. Yeah, with regard to the total shutdown, you know, with the 24 demands, that 24 demands were taken to a summit, and which was civil society and government, and the national GBV and femicide strategy then came out of that. And we, like I said before, there was a second summit. But what is very important in terms of the total shutdown for me was that it was ordinary women on the ground, not just civil society. It was women coming on the ground, coming out in numbers. And I'm not talking about that is not civil society. That is actually the reflection of the broader civil society. And women saying, and the more organized ones, it wasn't driven, like I said, and that was phenomenal. That was phenomenal in our country, and as a movement. I think that the total shutdown then took us to that next process to be able to engage. So for me, it's always been that that women in this country, as a collective, we do have power, and we've got power to be able to drive change like we did here. There's still a lot of challenges, but we forced government to come to the table and to be able to bring a council in that consisted of government, and it was situated in the presidency, and they then, you know, developed the policy and the plans. And this continued because I think it's important, that civil society and government should speak. We must obviously, as civil society, we must remain very critical. However, we also need to ensure that all the pieces of legislation works for the women on the ground. So I don't know if you want to know anything more about the shutdown, but I just wanted to place it in the context of a broader women's movement and a broader historical context, because we need to, and this is what I feel, that even though that we need to be able to build and continue building that power, because if things impacts on women and the state is not listening, the courts take very long. And so it means, how do we build that power to be able to drive change? So with the center, we call ourselves obviously activist lawyers, a feminist activist lawyer, because one of the issues for us is to be also to be able to drive change within the patriarchal systems of the courts, and to be able to ensure that what happens doesn't impact on women and causes secondary forms of victimization. So the activism is very important for transformation, and to be able to ensure that our constitutional imperatives, or what the Constitution has given us, is realized.
Yeah, thank you for that. And I think what I get out of that too is that how it was, women came out in droves and protested so much that actually pushed for the president to come up with this summit.
Yes.
So I think that is very important, that we can see how NGOs and just women at the grassroots level can push this kind of program. And you know, I guess the frustration is also that once there's this very big and high profile cases where women are killed or abused in a very horrific way, of course, and then there's anger, but then we move on. Yes, then we move on, and there are suddenly more important things to have to focus on, and it always gets to the bottom of the agenda, it feels like it. So it's constant pressure we have put on government, and I think that's important. But there's the issue of Ilham asking
yes,
about, yes, and how can you protect sex
there's a
workers?
lot of cases. You are correct. That's there are the sex work. It's still criminalized. However, there was a few cases which the Women's Legal Center did, Kylie, etc., that dealt with sex work within a labor context. Also the broader recognition of sex work as work. However, we formed part of a broader coalition which was called Asajiki, which is a decrim coalition that over the past couple of years we have pushed for the decrim of sex work. And so we are now currently, and so it's not something that has come on today. This has been many years of work to be able to ensure that there is decrim of sex work. Where it's currently, it is in a bill. This has also been driven through, for example, these 24 demands, the national summit, etc., the GBV bills. All of this was part of what civil society and women in this country wanted to see in terms of change. So even this decrim bill has come out of that particular process. However, we don't know in which form it's going to be, and we also know in this country, sadly, sometimes it gets to a bill, but then you can wait many years before it gets to the next process, or it just gets taken off. So it's very important for civil society, like the Asajiki Coalition, SWET, Sisonke, which is the Union of Sex Workers, all and different organizations to be able to push for the decrim. Yeah, so that is where we are at. You can also go on the Asajiki Coalition website, which has all the information around the decrim and where we are at and what we're doing in terms of engagement. We are putting pressure on the Department of Justice and government to ensure that it goes through in terms of this parliament. Because if you can imagine, we don't know, it's elections next year, in terms of the new parliament, the next 5 years. And so we are pushing hard to be able to ensure that it goes through this parliament.
The question also asks about how do you protect sex workers from violence if it's not decriminalized at the moment? How can you?
We're very creative.
How?
We're creative.
I can
listen,
imagine
the
that.
Women's Legal Center have been, we first we had a sex work clinic, with paralegals, etc., also, but then Sweat, our partner, because we do mostly the constitutional litigation, the clinic was set up by Sweat. And the type of matters that we mostly get, I'm telling you now, the sex workers don't get arrested for solicitation. It is extremely hard to be able to prove solicitation. And secondly, so in terms of what are they being arrested on, it's trafficking, loitering, municipal bylaws, which is not supposed to happen. Because there was a case that was done against the city of Cape Town or by Sweat many years ago at the Legal Resource Center that dealt with where they arrest sex workers and they don't charge them and release them the Monday, because then the entire weekend they will sit in jail. So we are also now currently busy with a broader case, because you need to see also this decrim and what the city is doing in relation to sex workers within a broader context of decriminalization of both poverty and sex work, because it intersects. So the current case that we are doing, that we came in as amicus with one of our big partners, which you can follow, is the Halderbloem case, which I don't know if you know, during where homeless persons were given tickets of 1,000 rand, etc. And those are all things that are being contested. We're looking obviously from a transgender women sex workers perspective that works on the street. And what does the bylaws of the city look like? So there's a lot in there. Yeah, that is a completely different conversation. If you want, I can get my women in work people to come talk to you more about the bill and what the challenges are, or we can send you the documentation and we can engage on it. If I say, it would be great if we send information rather before and engage on content.
Are we going to take you up on that, Seehaam?
No, definitely.
That we go forward and do some more work around this, because there's so many students doing the compulsory research paper in final year on issues of violence against women.
Yes.
And so I think it's important if they get some more of this kind of information and engagement from people who are litigating these issues. I think it would be wonderful. The next two questions or comments are interrelated. And so I'm just going to sort of give it to you in one go. It's that we have such wonderful frameworks most of the time in Constitution. But what happens, for instance, if SAPS is not trained sufficiently, and you still have where it's not taken seriously, dockets get lost. In fact, police are involved in violence against women sometimes. So no matter how good your legislation is, it's just going to stop right there if the police, the enforcers, are not going to be following the legislation and the policy.
Which for us, yeah, you can, are you gonna, yeah, due diligence and accountability. We need to be able to ensure that the framework is implemented. One of the things is, and you are correct, we are not hiding that these are the things that are happening. However, we need to know what our structures are. And I know what you're thinking, oh, we are complaining. However, we need to be able to keep those people accountable. Because if there wasn't accountability, or at least if you can prove within the system, because this is what the court cases allow you to do now. If that impacts on you and something happens to you, you will be able to, bring a case in relation to the various pieces of legislation and show some form of secondary victimization. But like you said, the court system takes long. So how do we ensure that the right people are appointed and that this work is done? It requires a civil society. For me, there's many answers. We don't have it, but from our side, we need to have an active citizen. We need to be able to ensure that the structures is accountable. Our people need to be able to go to their parliamentary constituency offices. They need to be able to engage with the councillors. And I understand what you're saying here about threaten you and people get killed, etc. Which is why it's so important. Broader movements is very important, because it doesn't completely protect you, but it gives you a collective and a broader safety to be able to push. So you've got lots of housing assemblies, you've got Abashlali, you've got Shukamisa. There is a lot of movements and NGOs to be able to see that what your issue is and to be able to drive it through those processes. But after 2018, civil society is having a much more closer relationship now with government to ensure that the national GBV strategy is put in place. It is important for us as a country to be able to drive and understand what that strategy is. Because only through that strategy, we will be able to keep our counterparts accountable, whether or not it's through budgets, whether or not it's through engagements in parliament, etc., etc. So it requires a lot, but it requires education of the processes. The law and the courts can only fix so much. We know that. We can't drive complete social change through the courts. We need an active citizenry. We need to be able to ensure that the appropriate people are in place to be able to ensure that's accountability. I know what you're feeling is that why is this all placed on us? The problem is that we have a constitutional dispensation, and it's important for us to be able to live those principles and ensure that those principles are enforced, whether or not it's through the courts, whether or not it's through activism, through submissions in parliament, but we need to play an active role.
Thank you so much, Seehaam. I think that is about all we can take now, because we've come to the end of our time. But I would like to thank you. I think it's an empowering note that you ended on, that we can take back the power and we must do more. It gives me a positive kind of outlook on the future. But I am going to take you up on that offer of coming to speak to our students a little bit more and have some more interaction in the future. But for now, I would like to thank you for your contribution to this event and to the bigger 100+ campaign. We wish you well with your litigation that you have going on now, and thank you for all the great work that you're doing in the center. So thank you
Thank
so
you
much,
very
and
much.
thank you to everybody for joining us and for the questions that you've asked. I hope you learned quite a bit, and Seehaam, you will send us the slides, and I have the slides. I think I have them, and so you do give me permission to send it to the participants.
Yeah. Yeah.
Okay. So thank you very much, everyone,
Thank you.
and enjoy the rest of your day. If you're in Cape Town, stay warm. Bye-bye, everyone.
Bye-bye.
Thank you. Bye. Bernice.
Hello.
Hello. How are you? Did you enjoy that?
I did. It was very, very good.
Are you well?
I'm good because I'm just thinking about the topic because one of my master's students, is looking at sexual harassment and why it's so prevalent in higher education institutions.
Oh, yes. That is a big problem as well. Yes.
Yeah. But you, how
Okay.
are you?
Sorry, just let me